Ahoy sailors! Admiral John here with your favorite YouTube maritime legal channel, Live Fixture. Today we navigate the litigation waters by charting a maritime lawsuit from complaint to trial. So, batten down for some courtroom chop. This vlog series aims to equip seafarers with legal know-how because forewarned is forearmed before the bench. Now full steam ahead into admiralty law. Navigating the often choppy waters of a maritime lawsuit can be a daunting task for any seafarer. However, understanding the key phases of the litigation process can help crews sail towards resolution. This guide will explain the typical trajectory of a maritime case, the unique facets of admiralty law, and provide sailors crucial perspective before their day in court. The voyage begins, filing the initial maritime complaint. Like any civil lawsuit, a maritime claim starts with the filing of an initial complaint. This document names the plaintiff, the party bringing the lawsuit, and one or more defendants, the parties being sued. It then lays out specific allegations against the defendants and requests relief from the court, usually in the form of monetary damages. Lawsuits in admiralty law often derive from personal injuries, cargo damage, vessel collisions, pollution incidents, or breach of maritime contracts. When constructing the complaint, attorneys must strategically highlight why the case falls under federal maritime jurisdiction. Unlike land-based cases tried in state courts, admiralty disputes involve maritime activities or injuries occurring on navigable waters. Common jurisdictional hooks include the location of the incident on the high seas, the involvement of a vessel in navigation, or a contract tied to maritime commerce. Plaintiffs must emphasize these admiralty connections. Setting the course, litigation phases, and timeline. Once the suit commences, the litigation enters the pre-trial phase marking the voyage ahead. Initial disclosures, plaintiffs and defendants exchange relevant documents and name potential witnesses. This primes both sides for discovery. Discovery, extensive information is exchanged as parties collect supporting evidence through documents, interrogatories, depositions, and vessel inspections. Expert discovery, experts analyze evidence and provide opinions. A marine engineer may assess vessel conditions. A harbor pilot may opine on navigation decisions. Dispositive motions, parties ask the court to rule in their favor without a trial. Defendants file for dismissal. Plaintiffs seek partial judgment. Settlement negotiations, over 90% of civil cases settle out of court. Maritime suits are no different. Cost, risk, and time savings incentivize resolution. Mediations commonly occur near the tail end of discovery. Pre-trial orders and conferences. As trial approaches, the court and parties prepare the roadmap for trial procedures and logistics. The duration of this pre-trial workflow varies substantially depending on case complexity. While small maritime suits may conclude within a year, multi-party disputes can linger for several years before reaching trial or settlement. Patience is key. Navigating admiralty laws and procedures. Maritime cases also come with unique facets and processes. Here is a quick primer on key admiralty laws impacting maritime lawsuits. Legal doctrines. Seafarers should comprehend three pivotal admiralty doctrines. The Limitation of Liability Act allows vessel owners facing multiple suits to limit financial exposure. The Jones Act permits seamen injured by negligence to directly sue employers. Longshore Harbor Workers' Compensation Act provides shore-based maritime workers no-fault insurance benefits for injuries. Each doctrine sets parameters for liability and damages. Ship arrests. Plaintiffs can have vessels or cargo seized to satisfy a judgment. This prevents assets from sailing away while a suit pends. Admirals must consider bonds releasing arrested vessels during litigation. Traveling on board for inspections. Given maritime lawsuits commonly involve vessel casualties, attorneys frequently arrange on-board inspections to film, photograph, and evaluate conditions. Crews should anticipate visitors assessing evidence. Navigating international waters, many maritime suits involve foreign parties or incidents in foreign waters. Hiring local counsel abroad ensures proper service of process and compliance with foreign laws. Vessel arrests also rely on reciprocity between nations. One final wave, bench trials. Given maritime lawsuits fall under federal admiralty jurisdiction, jury trials are quite rare. Rather, judges adjudicate the disputes in bench trials with far more expedited timelines. Expert witnesses also play a heightened role educating judges lacking maritime expertise. This is just but one important voyage in a seafarer's career. Born voyage. For more informative and interested videos like this one, don't forget to subscribe our channel. Stay tuned.